Joining me now is Professor Laurence Tribe, Harvard Law School Professor Emeritus, who has decades of experience arguing and studying the Supreme Court. It's a great privilege. Thank you for being with us. Thank you so much.
Thank you for having me, Andrea.
Well, Professor Tribe, on immunity, first of all, do you expect an appeal from Donald Trump today? And then what do you expect the Supreme Court to do? Is there any way to figure whether, even though the appeals court ruled that it had little, if any, merit, whether they would want to put their stamp on something that had never before been decided by the High Court?
Well, Donald Trump has another 11 hours within which to seek a stay of the decision of the D.C. Circuit, the unanimous decision rejecting his extraordinary, extravagant, and unprecedented claim of immunity. I don't expect that the U.S. Supreme Court will grant his stay. There's really no basis for it. It's simply a delaying tactic. And I also don't think there's any good reason for the U.S. Supreme Court to grant review of the case. So I think the odds are really very good that by tomorrow we'll be back on track before Judge Chutkan, and the clock will be ticking again. She won't be able to begin the trial on March 4th as originally scheduled, but it can certainly begin by late spring or early summer, and the American people will have an answer beyond a reasonable doubt as to whether Donald Trump did, in fact, try to steal the 2020 election by committing the very serious crimes that are charged by Jack Smith in this indictment. And it's very important to note that although the label of the indictment is not insurrection against the Constitution, it is not the label that counts, it's the content. If in fact he is convicted of trying to undermine and destroy the Constitution's central pillar, which involves the transfer of power from one president to the next, that will satisfy what Section 3 of the 14th Amendment identifies as an insurrection against the Constitution. And it will legally disqualify Mr. Trump from ever again holding the office of president, whatever the Supreme Court says in the Colorado case, which raises a rather narrower question of whether an individual state may exclude Donald Trump from its ballot.
You seem rather confident that the court will not weigh in, will not further delay the start of Judge Chutkan, because she's not been able to do any pretrial, hearings. She's not been able to do jury selection. She could have gotten an earlier start if everything had not been put on hold by his immunity appeal, which, as you point out, most legal scholars said was really frivolous.
I think it is frivolous, and I think even the current very conservative Supreme Court will have no reason to disgrace itself by playing into Trump's obvious gambit of simply delay, delay, delay. It will be obvious to everybody if the Supreme Court grants a stay in a case where it's inconceivable that it would do anything other than eventually affirm what the D.C. Circuit held in rejecting the claim that a sitting president can do anything he wants, kill his opponent if he wants, and then when he's out of office, he can't be prosecuted. There's no way the U.S. Supreme Court, and I would venture to say no way that anybody on the current court would agree with that. And given that they won't agree with it, it would be obvious to everybody that for them to grant a stay is simply to delay the accountability of this former president. The right to speedy trial is not just a right of the accused, not just a right of the prosecution. It's the right of the American people to know when they go to the polling booth whether the person they are voting for has been convicted of trying to steal the last election, committing a very grave felony and undermining the Constitution. And the only way the American people can know that is if we get going with the trial before Judge Chutkan. And the only way that can happen is if the court denies a stay. And that's why I think it's almost certain that it will do that.
What is your view about the controversy surrounding Special Counsel Robert Hur not just declining to prosecute from President Biden for taking classified documents and not handling them in the proper way, but for what he described as his lack of memory, his failure to remember many things during 5 hours of interviews. He does point out that he cooperated, unlike Donald Trump, that he didn't withhold documents, try to allegedly obstruct documents, urge others to obstruct or destroy documents, didn't have to be subpoenaed. But despite that cooperation, he went very far in a damaging political description of the current president.
Those gratuitous remarks were disgraceful. They were an abuse of power by Robert Hur. It's very clear that the Department of Justice, under its rules, even for a special counsel, precludes dumping on somebody that you've decided not to prosecute. After all, when you do prosecute someone, they have their day in court. They can defend themselves. Apart from a press conference, there was nothing Joe Biden could do to defend himself from those scurrilous remarks. I think it's clear that Merrick Garland, in his role as Attorney General, should have granted the request by the president's personal counsel, Robert Bauer, to either redact those unwarranted and improper comments or to insist that they be deleted. And failing that, Merrick Garland really owed the country his own statement explaining why all of that extraneous stuff was irrelevant and why the relevant conclusion by Robert Hur, who had been appointed despite the fact that he is a very conservative Republican, the relevant conclusion was that Joe Biden committed no crime. He was careless. A lot of people are careless, but he did not commit a crime. And the distinctions between his careless retention of some documents that were classified, but then cooperating fully with the government's request to get them back, the distinction between that and the blatant obstruction of justice that is charged against Donald Trump in the case pending before Eileen Cannon's court, that distinction is sort of night and day. And the suggestion by Donald Trump in his quite frivolous motion that this was selective prosecution, the latest gambit he's playing before Judge Cannon, is just without any merit. Although given Judge Cannon's record, you never know what she's going to do next. And I think the time has come, and it will, I think, be upon us soon, for Jack Smith to seek in the 11th Circuit to have her removed from this case, because she has handled the prosecution in Mar-a-Lago in a way that has taken what should have been an open and shut case and dragged it out and played along with the former president's desire to delay and thereby avoid accountability until after the election.
A lot of suggestions there, Professor Tribe. Thank you very much. I should point out, we have to leave it there, but that the Attorney General was a former student, a constitutional law student at Harvard.
He is, and I admire and like him, but I think he has handled this very badly.